Lucas, on count one, do you admit and plead guilty to the offense of murder?
Yes, sir.
On count two, do you admit and plead guilty to the offense of murder?
Yes, sir.
Tiffanie Lucas, the Kentucky woman who shot her own children in the head, is now accepting full responsibility for murdering them. Lucas officially entered a guilty plea for the murders of her two children, bringing an end to her previous bid to plead insanity and leaving her fate in the hands of a Bullitt County judge now. Will she spend the rest of her life behind bars? Well, I'm going to talk with the prosecutor on this case as we look ahead to Lucas's sentencing. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. An expressionless, stone-faced Tiffanie Lucas faced a judge in a Bullitt County courtroom this week as she officially entered a guilty plea to 2 counts of murder. And I don't think that we can ever forget what she did here. 33-year-old shot and killed her own sons, 6-year-old Maurice Baker Jr. and 9-year-old Jayden Howard. This was back on November 8th, 2023, inside of their home in Kentucky. A neighbor told police that he pulled into his driveway to see Lucas walking down the steps of the porch, telling him that the kids were dying before she collapsed in his driveway. He ends up running into her home in an attempt to save the boys, sees this horrific scene, and calls 911. The children were rushed to a hospital where they later died. Now, here's where things took a very interesting legal turn. You see, just last month, Tiffanie Lucas informed the court of her intention to use the insanity defense, her insanity plea, though she was not going to challenge her competency to stand trial. It's 2 different things. And to be clear, this means that she wouldn't argue that she didn't commit the shooting, but when we talk about the insanity defense, it would be that she's not criminally responsible because she was not legally sane at the time. Here's the way it's defined under Kentucky law. A person is not responsible for criminal conduct if at the time of such conduct, as a result of mental illness or intellectual disability, she lacks substantial capacity either to appreciate the criminality of her conduct or conform her conduct to the requirements of law. Now, to be clear, Lucas did say some pretty wild things in her interviews to police about what had happened. She claimed that she would never do something like this unless someone manipulated her into doing so, and that she was being manipulated through Facebook, through her internet. She also indicated that the gun used in the shooting was given to her by someone else, and that she had left it in the bedroom, claiming the shooting was an accident. And in a previous hearing, a detective testified that that weapon was fired 4 times in a matter of 30 seconds. You want to talk about something being deliberate? Well, this week, in a seemingly change of heart, she told the judge she was ready and willing to accept the ramifications of entering a guilty plea. Take a listen.
Do you suffer now, or have you ever suffered from any mental illness or defect which would affect your ability to think and reason?
No, sir.
At this time, are you ill or are you in any way impaired in your judgment?
No, sir.
Are you under the influence of alcohol or any other type of drug?
No, sir.
Do you understand what's happening in court at this time?
Yes, sir.
Yeah, Lucas was just in court a little over a week ago where her team had indicated, her legal team had indicated this change in plea. And she ended up entering what's called an open plea, meaning she was pleading guilty to her crimes, but without a plea deal. There's no sentencing recommendation from prosecutors here. There's no agreement about what the sentence will be. That is now going to be left up to the judge to decide what her punishment will be, Judge Rodney Burris. By the way, as you guys may know, we have been following the Tiffanie Lucas case from the very beginning, right when we heard about this horrific set of killings. And we have been trying to always update you on what's been happening in this case, to analyze these issues as they develop. And one of the reasons we're able to do this is because we have amazing support from our sponsors. And I just want to call out one in particular right now, Morgan & Morgan. Look, if you're injured, America's largest injury law firm, they may be who you want in your corner. Not only is there no upfront fee, not only can the whole process be done straight from your smartphone, super easy, not only do they have a dedicated army of 1,000 lawyers and specialists and paralegals, but they also have an incredible track record. In fact, recently, they secured verdicts of $6.8 million in New York, $12 million in Florida, and $26 million in Philadelphia. And all of these, mind you, considerably higher than the highest insurance offers in these cases. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar. Now, one of the things that makes this case so chilling and eerie and strange is that if you look back at photos and videos, Lucas appeared to be pretty happy with her kids.
You walking? Are y'all shopping? Yeah. Go Peanut. Go Peanut. Go Peanut. Go Peanut. Yay. Peanut. What?
It's so strange. It doesn't make sense. Now, last year here on Sidebar, we talked with Michelle Rice. This is 6-year-old Maurice's stepmother. And she told us a different story of what was going on behind closed doors.
So when little Reese was little, as a young child, you don't really know what not to say. So he was the one that was letting us know, like, he was being left at home with just his brother, or being left alone in the car with his brother, and mom locks the car, things like that. So we were aware of things, then things she was into and things like that. So it's not like, we kind of know her background. We know her background and stuff like that. She wanted people to see her as a certain way, but that's not really how she was. That's just how she wanted to be seen as, like on social media. Nobody really knew, behind the scenes of her, like her drug issues. She never had a job. She never worked, things like that. Like, the boys were taken from her previously, when they were smaller, do drugs, things like that. But they were given back.
When we talked with Rice, she said she wanted the death penalty for Tiffanie Lucas, fully believing that Lucas deserved to die for what she now has admitted to doing to these 2 young boys, her sons. But now that she's taken a plea, the death penalty, that's off the table. When she's sentenced on November 22nd, it's our understanding she could face 20 to 50 years behind bars or life in prison on both murder counts, and it's going to be up to the judge to decide whether the sentences will run concurrently or consecutively. Okay, so now I want to introduce you to a special guest. We are joined by the prosecutor on this case, Bullitt County Commonwealth's Attorney Bailey Taylor. Thank you so much for coming on. Really appreciate you taking the time.
You're welcome.
So I want to start by asking what your thoughts were on Lucas initially pleading not guilty, then intending for her to argue legal insanity, now switching her plea to guilty. What do you make of that?
Well, it was kind of a roller coaster ride. At the time that the tragedy occurred, we fully intended to go to trial. The policy in Kentucky is when a capital crime is charged and they are using the Department of Public Advocacy, they bring down what's called a capital crimes or capital trials branch, specialized attorneys that deal with these types of cases. And over a few months, we discussed the case. And at one point, we were discussing the possibility of a plea. And then the attorneys decided to file the intent to seek an insanity defense. And we filed the response that would essentially mean that there would be a complete evaluation, but it would also move the trial down the road a minimum of 6 to 12 months because of the backlog at the Kentucky Psychiatric Hospital that deals with inmates. Then at that point, I was advised that they wished to change their plea to guilty and make it as an open plea with no agreement with the Commonwealth.
What do you think the change was? Do you think it was, hey, we don't want to wait 6 to 12 months to go to trial, which, I mean, she's now looking at a long time in prison? Or do you think it's, we are concerned about what the evaluation would show, that maybe it wouldn't have helped her argument for insanity?
I think that it's perhaps a combination of the two. This was a case that had, or each side of the case had its own liabilities if the case went to trial. And I think they realized that there was a considerable amount to lose were they to go to trial.
And what would have been the risk for the prosecution in a case like this? I mean, looking at the fact pattern of it, it seems relatively straightforward, but was there a concern that perhaps she could mount an insanity defense, that perhaps she could be found not guilty by reason of insanity?
Well, one of the issues with an insanity defense in Kentucky is once that issue is raised, the Commonwealth has to respond to that and rebut it with proof beyond a reasonable doubt. So that is always an issue out there. I've never thought that the guilt phase was going to be a problem in this case. I thought that because there's really no issue about the guilt except for the criminal culpability, because there's no whodunit, there's no hidden gunman, anything like that. What I did have some concern about was if we went to the sentencing phase, apparently Miss Lucas had had a lot of problems in her past. I won't go into detail, but I thought that there was a possibility, not a great possibility, but there was a possibility that if we went to trial and got into the sentencing phase, that the jury might deliver a sentence that would be considerably less than what I would like to see.
And just to be clear, under Kentucky law, if this went to a jury to decide the punishment, not the judge, what would have been their options if she was convicted?
Well, the options that would have been, as the case stands now, would have been the same as what we're facing, which is 20 to 50 years or life without the possibility of parole for 20 years.
Right.
If we had decided to file what are called aggravating circumstances, then it would have opened the door to life without parole for 25 years, and also the death penalty.
Right. Okay, so that makes sense. Let me ask you this. The idea of this not going to trial, there's a lot of reasons why it saves time, expense, the heartache of a trial, the jury having to see the autopsy photos of these young boys. Do you feel almost a sense of relief that this is not going to trial?
Yes, I do, because the victims, the relatives of the two boys, Jayden and Maurice, it's going to be something that's going to haunt them and punish them for the rest of their lives. But now they won't have to do it in the context of a jury trial, where, as you said, there would be the display of autopsy pictures, at least to some degree, in the testimony of the officers and on. And essentially, it re-victimizes the victims having to hear it all again in public.
Do you have any sense of why she did this?
Well, if you've looked at any of the reports, she was apparently very paranoid and believed that people were trying to influence her through the son's PlayStation and through her phone. And she felt, apparently, and this is just speculation on my part, but I think she was in such a warped frame of reference that she felt that she was actually rescuing the boys by keeping them from being abducted or whatever she thought was going to happen by some evil entity.
So just to clarify that, that's what she had been saying. Do you believe that?
Yes.
Do you think a jury, you think a jury would have believed that?
I don't know. She did have a very troubled childhood. And as you well know, being an attorney, there's no guarantee on what a jury's going to do in a circumstance like this. The thing is that I do find concerning is that everything that I've heard, or not everything, but most of what I've heard, is she wasn't a bad mother. There weren't any issues involving prior abuse or that type of thing. Apparently she did have possibly had some drug issues. I don't know that for a fact. It just seemed to be reasonably out of character for her to just do that out of the blue.
What are you pushing now for sentencing? What are you hoping for? What are you going to be advocating for? What do you think the appropriate sentence is?
Well, there's several possibilities. What I'm looking at right now is either the possibility of 70 years to serve or life without parole for 20 years. I will probably go with life without parole for 20 years, but there are just little factors that might enter into why I might want to do a 70-year verdict instead of life.
Are there any factors that you can share?
Well, basically, it's dependent on how parole eligibility affects the 70-year sentence versus the life without parole for 20 years.
Do you think that there is a scenario where she could be released from prison?
That would be up to the parole board. I would be very surprised if she was ever released.
And this judge, Rodney Burris, correct? Judge Rodney Burris, In
Yes.
your estimation, how has he handled these kinds of cases before, based on your recommendations? I mean, we're talking about the killings of 2 young boys. Where does he typically go in terms of sentencing in similar cases? I don't know if there's been a similar case like this in your jurisdiction.
Well, unfortunately, I've had to deal with several murder cases. In fact, I have about 2 or 3 still pending. This was probably the most notorious. The only one that came close to it was a case that you may be familiar with. It involved Serenity McKinney, the girl whose body was found in a suitcase
Yes.
in our county. He will generally, in my experience, I'm not speaking for him, he generally follows the recommendation of the Commonwealth in the situation involving an actual plea. I've never dealt with an open plea with Judge Burris before. I was a district judge from 86 to 2014, and occasionally you had, in these limited jurisdiction, you'd have an open plea on a relatively minor misdemeanor. This is the first experience I've ever had where somebody actually makes an open plea on a capital offense. My inclination is if he errs, he will err on the high side.
And was it an open plea where the defense said, listen, we're going to plead guilty to this, but we're not working out any kind of sentencing. We're leaving it to the judge to decide that. Or was it your office who said, we're not interested in actually a plea deal per se. You want to plead guilty, but we'll have the judge decide it. How did it work that this was an open plea?
They decided that they wanted to make an open plea. And of course, in a situation like that, the Commonwealth really can't object because there's no plea agreement in place. They're just essentially throwing themselves on the mercy of the court.
Yeah. And do you know at this sentencing hearing whether the boy's family will be providing victim impact statements, what they want to say to the court, if they're going to say anything to the court?
I've only talked to them briefly since the open plea was announced. I know several victim impact statements will be provided. I don't know at this point if any of the victims' families are going to want to address the court specifically.
Can you tell us how they're doing at all?
Well, I think it's just a situation that's just been extremely traumatic. I think that particularly in the case of a couple of the family members, they've expressed, and I don't have any personal knowledge of this, that they had tried to have the social services involved and nothing took place, but I'm only going by what they said. We don't have any independent knowledge of what happened with social services. But I mean, it's obviously 2 young boys that are just, killed in a matter of seconds and in a very brutal manner. It's something that if you're a relative, an aunt or a parent, it's just heartrending.
We spoke with Michelle Rice when this first came down, not this decision, when Tiffanie Lucas was first arrested.
Mm-hmm.
She had told us she was advocating for the death penalty in this case. That's not going to be an option now. Do you think that is, do you think that's not in the interest of justice that the death penalty is no longer on the table? Are you disappointed that's no longer an option to be considered given the gravity of these crimes?
No, but here's the situation. I'm not anti the death penalty. However, you have to deal with the situation in Kentucky and what's the likelihood of the death sentence ever being carried out. The last execution in Kentucky was in 2008, and that gentleman was a voluntary execution. He didn't present any appeals or resistance. And the last woman executed in Kentucky was in 1868. Now, Russell Coleman, who's the Kentucky Attorney General, is moving forward to hopefully to get the death penalty actually being used, but that's still a bit down the road. And then the other thing is the Kentucky Supreme Court, it's a direct appeal to them if there is a death penalty verdict. My experience has been with the Kentucky Supreme Court, they will err on the side of caution and will most likely return or remand the case for a new trial or a new sentencing hearing. So in that case, then you're back to square one and going through the whole process again.
Yeah, that would not be good for anyone involved. So I get that. I understand
No.
the complications involving that. Before I let you go, your final thoughts on this case. I mean, I cover crimes every day. This is one of those cases that is stuck with me for a variety of reasons. I think this is an incredibly difficult one to talk about, an incredibly difficult one to comprehend. This happening in your jurisdiction, this affecting your community. What do you think about this case?
All I can really say, it's sad. I mean, as I said, there's two young boys that were literally executed, and it has an effect not only on the family but on the community at large, because it's been a very heavily covered case, as you would expect it to be by the local news media, and it's just impossible, I think, to wrap your head around it in a lot of ways.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.